So I wound up going back to law school, and I've got a law firm, Ambler, Keenan, Mitchell Johnson, and we are an estate planning firm. So we do wills, trusts, powers of attorney, trust administration when people pass away. But in dealing with that, we deal with a lot of businessmen and a lot of business entities. So this presentation is actually a continuing ed presentation that we did. And it talks about the different ways you can do business, as an LLC, as a corporation, as an S-Corp, and all of that. So let me ask, how are you guys all doing business now? We were talking about licensing agreements. I'm assuming that's royalty payments that go to Schedule E. Is that how that gets treated?
Well, you know, that's a good question, because the tax treatment of your royalties, I think, depends on your other incomes, and
Okay.
because you probably want to do it differently. You'd have to look at each
Okay.
case.
Is anybody into like actually manufacturing their invention and selling it, or are we all more? Okay. All right. So some of that's pretty relevant to us. So what I'm going to do is I'm going to just flip through all these different ways you can do business. And as we get into them, you're going to find out pretty quickly some of them are not the way you want to do business. Absolutely guaranteed. And in the end, it comes down to 2 or 3 different choices. And I think those are the choices most everybody winds up working with when they wind up doing a business type entity. So basically, why one entity over another? The issues always are, first of all, ownership. Am I the only owner? That's an easy way to work with a business. Do I have multiple owners? In multiple owners, I'm going to need some kind of structure to recognize everybody that I'm working with. Control and management. When you're one guy or one woman, it is really easy to make things work. But as soon as you wind up with more people in there, some of these structures make it easier to control things, and some of them make it quite difficult. Income tax, always a biggie. Absolute biggie. Now, this presentation was done before the new Tax Act came out. The new Tax Act changes a few things in here, and I'll talk about that right at the very end. The problem with the new Tax Act, he signed that on, what was it, December 21st, I think? I still have not found a decent analysis of it. I've heard the stuff on the news, I've read the stuff in a Wall Street Journal, but as far as going to a class and having somebody tell me it did this, and this, we don't have it there. So I think the CPAs are probably going to get that before it trickles down to me, because they're all getting hysterical with tax season coming up anyway. Asset and creditor protection. Always important to have creditor protection. People don't understand. You hear these ads that say create a corporation and you're absolutely protected from anybody ever suing you. Not so true, okay? So we'll talk about that. And then finally, business succession. How do you make it pass down? If it's an actual manufacturing type business, how do you pass this down to the next generation? If it's simply a patent that somebody owns, we can transfer it from one to another person. But an operating business is a lot more difficult to do that with. So this is the laundry list of all the different ways you can do business, okay? And I'm going to take one off right at the top, right in the middle, professional corporation. A professional corporation is a corporation that has to be owned by licensed professionals. So it is typically going to be CPA firm, law firm, architecture firm, veterinary, doctor, dentist. So absolutely irrelevant to us, okay? But the rest of these, there's a possibility for all of them. I think everybody pretty much starts as a sole proprietor. The absolute easiest way you go into business. You say, hey, I'm in business, I own this thing, you get a name to do business under, and you start doing business. It's easy to establish and operate. You just open the door and you're going. You don't have to go down to the Secretary of State and file anything. You don't have any special tax forms. It's all going to go on Schedule C in your tax return. Nice and easy way to do it. And basically, you can transfer all your assets. You have total control of the business. Owner pays all the taxes. Pretty straightforward, okay? But it's got other problems with it. You're personally liable for everything in that business, okay? So something goes wrong, the delivery kid takes your car and runs over somebody in the crosswalk, that's your problem. Respondent superior means that if your employee does something, you're liable for his actions. And there's really no protection anywhere in here. You own this stuff. If somebody sues you, you can lose all the business assets in there. The way a sole proprietor works, when you do your taxes, let's say we get down to the bottom and we've made $100,000 for the year. That's a really great deal, okay? What they do is you have to pay self-employment tax because there was nobody taking your Social Security out, right? So what happens is you basically give the government 15.3% of the profits for Social Security. So now you got about $85,000 left. And then you pay income tax on the $100,000 that you earned. So you're kind of really getting burned over that Social Security tax because you're paying income tax on it even though the government's getting it, okay? Probably not the best thing in the world. But you can have all the different retirement plans. It's tough to borrow money as a sole proprietor. The bank doesn't really want to see you. So that's probably not a great thing. You sort of lack credibility, you know? It's like, hey, I'm Jack and we're Jack's window washing service here. And people just kind of go, that's okay, when you're trying to establish credit and do things like that, okay? Terminates at death, and transfer can be pretty cumbersome, okay? There's not a real clear structure. I mean, if I'm in a corporation and I want to sell it, I sell you my stock, it's your corporation, okay? In a business entity, not so easy when you're doing sole proprietorship. Okay, general partnership. So a general partnership is really easy to create. Brian and I decide we're going to be partners, and we are now a general partnership. We don't even have to write new rules up. The state statute book has all these default rules we can use to do everything. We can divide the profit any way we want to. I think 90-10, big end to me. Brian thinks 90-10, big end to him. We're going to work that out. Partnership income is taxed to us individually. So what's going to happen? It's going to wind up getting taxed on I'm going to have Schedule C for whatever the heck my profit part of it was. He's going to have one for his. They're going to nail us to that self-employment tax again. Okay? Partnership assets are normally protected from personal creditors. That's probably one good thing for us. It's got more sources to borrow money. That's a little good thing. And it's a little less administratively burdensome than corporations. So when I get to corporations, I'll talk about annual meetings and all this kind of stuff. But the big disadvantage, each partner is liable for all partnership debts. So that means that if Brian takes his car and runs somebody over in the crosswalk and cripples them and they sue us and get $5 million, and they come after me, they can take the whole $5 million out of my hide, even though I had nothing to do with it, okay? So the first thing you learn in law school, never get in a general partnership, okay? There is just too much liability, and you can get burned really too bad in it. Each partner can bind the other partners. I'm going to buy a new truck. You're going to be on it with me because I'm signing it as a partner. I mean, you really don't have any protections in there, okay? Other than choosing somebody good to be in business with, but that can still be a problem. You never know what's going to happen with that, okay? So 15.3 tax I talked about. Partnership income tax to a partner, even though it's not distributed. They call that phantom income. It's the most fascinating thing I've ever seen. We earn $100,000 in the partnership, and it's a profit, and at the end of the year, instead of taking the money out, we buy 2 new trucks, okay? Well, the IRS says that we made $100,000 and we each got $50,000. Even if we didn't get the money, we're paying tax on it. So you could wind up really getting screwed over a profit that you never got and not even have the money to pay the tax with it. And it's got some pretty complex tax rules in there, okay? Notice the list of disadvantages continues to go on. I mean, enough said for general partnership. Not a winner, not the place to go. Limited partnership. Limited partnership doesn't really lend itself to what we're trying to do here, okay? Normally you see limited partnerships, they're kind of investment vehicles where we're gonna do some kind of oil and gas thing, and I'm gonna be the big boss, and I want everybody to invest $100,000. I've got your money. I have a duty to deal with you on a fair level, okay? But you have no vote, you have no say, you get just basically what happens. A general partner inside of this limited partnership is in charge of everything. It simply doesn't lend itself to doing business like we're talking about. Much more of an investment vehicle, sometimes an estate planning vehicle. I'm gonna just skip right by them. So that's gonna take me to corporations generally, okay? So, corporations, you have to create at the Secretary of State. And you can actually do it online, and you can simply go in and say, I want to create the XYZ Corporation, and you say how many shares of stock you're going to issue, you're going to say who the initial owner is, you do a set of bylaws, and it's a corporation. Really not too hard to do. It has centralized management. So what you normally have is the shareholders, when you first create this thing, elect the directors, okay? And the directors hire the officers, and the officers run the company day to day. Now, in a small corporation with 3 people, you and I may be directors, we may be on the board of directors, we're probably gonna be president and vice president. I mean, we're kind of everything, you know, 2 or 3 people, everybody's in the mix. As it gets bigger and bigger, easier to manage though. Limited liability of the shareholders. Now this is the one that always kind of gets confused, and it gets confused because they tell you you're never liable. Create a corporation, create a limited liability company, nothing's gonna hurt you, you're bulletproof. So the example I'm gonna use is a rental house, okay? I buy a rental house and I create a corporation or a limited liability company, and I put the rental house in there. So the theory is we're gonna rent the house, the tenants are gonna be in there, somebody's gonna slip and fall or break their leg, or the furnace is gonna blow up, and nothing's my fault, okay? And nobody can sue me. Not really true. So suppose the furnace blowing up. I hire XYZ Heating and Cooling, and they go in there, work on the furnace, and it blows up. I'm not liable, okay? I owned the corporation, I took good steps to put qualified people in there to do the work. I'm not gonna get sued, I'm not gonna get burned on that. But suppose to save money, because I've got these tenants in there, I go in and adjust the furnace, and then it blows up. I was the idiot that caused the accident, okay? They're gonna sue the corporation or limited liability company, whatever it is, and they're gonna sue me. It's just like in my law firm. If my partner commits malpractice, they can sue my partner and they can sue the firm. They can't sue me because I didn't commit malpractice. But if I was the guy who made the mistake, they can always sue you. So General Motors, when you buy some GM stock, you're pretty bulletproof, right? You're way down a second order in that deal. But with a business that you're running every day, it is possible to get sued. The other thing is sometimes they'll argue and they'll, quote, pierce the corporate veil. So the corporate veil is seen as the corporation, and it's around you and it protects you, okay? It's the veil, and it's kind of bulletproof. But there's formalities you have to do with a corporation. You have to have those annual meetings, we've got to have directors, we've got to have officers, we've got to file tax returns. There should be a corporate bank account. I should not be using it like my little personal slush fund and, you know, paying paychecks out of it and paying providers out of it, and taking $50 and buying flowers for my wife and doing all this stuff. It's supposed to be a business, and you have to respect the entity. If you don't respect the entity, they could pierce the veil and sue you there too. So when you're in these things, you have to follow the rules to make it work right, okay? Assets protected from creditors of the shareholders, that would make sense. If we all here join in a corporation and we're doing business and somebody sues me over something personal, they shouldn't be able to get the assets of the corporation because I don't really own them. I'm merely a shareholder in there. They may make me give them my interest in the corporation, my shares of stock, but they shouldn't make the corporation disperse money to that person. The corporation didn't do anything to them. It's easier to raise capital as a corporation, although what you will find is when you go into the bank, the first thing they always want after they work all the way through this is they'll tell you, well, I need a personal guarantee. And the personal guarantee is we're borrowing this money in the name of the corporation, and if the corporation doesn't repay it, I, the personal guarantor, guarantee that you can come after me and I'll pay it. So you'll see that up into fairly good-sized business things. They still make us a pretty good-sized law firm. They still make us have a personal guarantee on the lease and stuff like that, personal guarantee on a line of credit, because banks are just scared they're going to get clipped. You've got to be a pretty good-sized operation before they're going to let you do anything without having that personal guarantee.
So can
Yeah.
that liability kind of be parsed out? Like, if I form a corporation, I'm new, I'm not real established, so I have to give a personal guarantee or collateral to your loan.
Uh-huh.
But maybe I can like lease some property just in the name of the corporation to not, I mean, I can do
They'll
other
let you
things
do
that I
some.
don't have to do
The
personally.
bigger the deal is, the more they're probably going to make you guarantee it, okay? If you've got a really good-sized business and you've got a good reputation, maybe we can get away with buying a couple of cars or a couple of trucks, and they'll be in the name of the business. But a really bigger deal, the bank, I think, wants to be protected on and wants to be covered on. And I've seen banks ask for crazy things in deals. I want life insurance on you, I want you to guarantee that you'll make the payments, and I want you to pledge collateral against this loan. And it's just like, oh my God, why am I even doing this, you know? They've got like, you know, $1 billion assets guaranteed against a $300,000 loan. Okay, we were there. Whoops. Flame out. Well, they just don't make them like they used to. I'm not sure what you will. Well, that didn't work so well. All right, found the right key. That's a good sign. Okay. I talked about the formalities of the corporation being observed. Okay, gotta do that. When you're in a corporation, you don't get a draw. And when you're a sole proprietor or a partner, you take a draw. You just say, I want, $10,000, and they distribute part of the cash in the business to you. In a corporation, you wind up getting a paycheck. So you wind up with the federal and state withholding and paying Social Security and doing all of those things. I've heard people say that the happiest day and the saddest day in their whole life was when they hired their first employee, because you wind up with a bunch of paperwork you have to do for all those paychecks. You got unemployment compensation, you got income tax, withholding, everything. So this one that talks about shareholder employees have to take a salary, just can't take dividends. Hold that for 1 second. I'm going to talk about that on S corporations, because that's where people really abuse that, okay? I think that'll make more sense over there. And then you've got a multitude of taxes on all of these that they really has just decided to give up the ghost here.
You wanna get mine? You got more slides?
Nah, it's fine. I can figure out which button it is now. I don't know what I did. So bottom line, when you create a corporation, there's two different kinds of corporations. There's a C corporation, which is what you get if you go online and create the corporation. You can then make a tax election and be an S corporation, okay? Big difference between the two. So I'm going to start with C. When you start the C corporation, you simply create it online with the Secretary of State or have your lawyer do it, and it's up and operating, and you don't make a tax election. So you can have as many owners as you want. Basically, you're GM if you want to be, okay? You can be that big. There's different classes of stock, because we've heard of common, and we've heard of preferred A and preferred B and all this kind of stuff. In a plain C corporation, you can have all that complexity in it. Fringe benefits are deductible. 1244 stock is when you first create the business. If the business basically goes under, you can take a write-off against all the stuff that went in there. That stuff's available in the C corp. It is a corporation, more difficult to form. You can't just say, we're in business. business, you gotta follow through the Secretary of State. Pretty heavily regulated. But the biggie on a corporation is subject to double taxation. And if you heard them all talking about the corporate tax part of the new bill, they were talking about reducing taxes on corporations. For a C Corp, the way tax works, or at least it used to work, I'll start with the old one first, is the business makes a profit. They take that profit and it pays a 35% income tax rate. That's what it used to be, okay? And they've lowered that to, I think, 21.
Was it progressive at all, or was it just a flat?
I don't believe it's progressive. I think it's just there. The other thing that happens with it, though, so how you get the money out of the corporation is what GM does, right? They declare a dividend and you get a dividend check. Well, if the corporation paid 35% on the profit and you get a dividend check and you pay 20% on your dividend check, there's a hell of a lot of tax there. That's when they refer to a corporation paying double taxation, and that was what they're talking about. The corporation paid the tax, and then when you got the money, you, the shareholder, you paid the tax. You can't pass losses through to the shareholders. So if GM makes money, they pay us all a dividend. That's a good thing. If GM has a crappy year, they may not pay the dividend, but we don't get to write off the loss, okay? And that's going to be different when you get to the S Corp. You'll find a lot of people doing business. Oh, I keep trying to use that. It's just not going there. So S Corp, there's no double taxation. S Corp is what's called a pass-through entity. So if an S Corp makes $100,000 at the end of the year, it does its tax return, and one of the pages in the tax return is a thing called a K-1. And we got two partners, and let's say there's 60-40 partners, okay? I, the 60% guy, get a K-1 that says I have to pay tax on $60,000 of profit. And the other guy gets a K-1 that says you gotta pay tax on $40,000, okay? But there was no 35% tax at the corporate level. That never happened. It just came straight out and I had to pay the taxes, okay? So we didn't deal with the 35%, and when it comes to me, I pay tax at my tax bracket. So if I'm not earning very much money, maybe it's 15%. If I'm earning a lot of money, maybe it's 39%. Just depends, because you're into that progressive tax structure that you were talking about before. Now, that just changed in the new tax bill. And they said that pass-through entities only have to pay tax at a 20% rate. Well, if you make $500,000 at an S Corp, you used to be paying taxes at 39%. Now you're paying tax at 20%. So that's going to be a big deal for people in business that have S corporations, and we're going to see, I think, a lot more S corporations formed to make that work. That applies to any pass-through, and I think it applies to any pass-through entity. Again, I haven't seen the structure of what the heck the Tax Act really says, just what the commentators have said on TV. So the other thing it says here, remember I had that thing I blew by and it said that shareholders have to take a salary, they just can't take distributions. Well, the big game that we all play in an S corporation is if I have $100,000 worth of profit, if I got that as a guy with a sole proprietorship, remember I would have paid 15.3% self-employment tax and tax on the $100,000. Well, the government recognizes that if you're in a corporation and you're an owner, you have, and you're working there, you have a right to be paid for your work, and you should be paid for your work, but you also have a right to share in the profits of that business because you've risked your capital and your intelligence in running the business and everything. So what a lot of us will do with an S Corp is if I think we're going to make $100,000, I'm going to make your salary $50,000 that year. You're going to pay not self-employment tax. You're going to have 7.5% or 7.65% withheld for Social Security, and the business is going to pay the other half. And then you're going to get a salary of $50,000, and you pay income tax out of that, and that's your W-2, okay? And the other $50,000 we're going to give to you as a dividend or a cash distribution. And this is the recognition of your hard work as an owner and the risk to your capital and everything. Those distributions are not subject to self-employment tax. So what you could wind up doing is you can take that 15.3% you were paying on $100,000 and pay 15.3% in essence on $50,000. You can save quite a bit of money. I mean, just doing that is $3,500 there. And there's other ways that you could wheedle at it in there. So a lot of times, that's where you'll see the S-Corps coming in, and that's what you'll see them doing. Lawyers are famous for trying to screw the system. There is nothing else to be said about that.
That's a surprise.
Yeah, I know, but I promised one new kernel of knowledge here. And a lot of lawyers, and CPAs too, would say, well, you know, hell, I'm just not going to take a salary this year. I'll just take a distribution. Well, if you think about that, Social Security just got beat out of 15% on $50,000. So if they find that, they will go after you. And when they find a lawyer or a CPA, they try to make a little example out of them so that everybody else follows the rules. But you can't just take a dividend and not a salary. And that's what that little bite there was talking about.
Is the distribution, is that taxed at regular rates though?
So the distribution is taxed at regular rates, but so's your income, no matter what you make.
So
If you
the
got to,
main thing I just get out of Social Security.
you get out of Social Security.
And that's only in an S corp I can do that,
Only in an S corp.
not in a partnership or sole.
Well, you can do it in a C corp, but you get the double taxation. Okay? You can't do it as a sole proprietor, because they're just burning you for everything. You can't do it as a partner, because remember, they assume in a partnership they're going to divide the profits. You get it on a K-1, and it's earned income, and it's all subject to Social Security tax, all subject to ordinary income tax. So S-corps can really help you. Okay?
So what would, just as a tip, what would be a rule of thumb on my split of income to distribution? Like you said, if I go all distribution, it's gonna raise red flags.
Okay. So hold that thought for a minute, because I got some numbers at the end where I tried to play games between pick one or the other. Okay? So that's a great question, but you're about 5 slides ahead of me. Okay? But things about an S-corp, because it's a favored tax status, they've said there are certain things you have to do. You can't have more than 100 shareholders. All the shareholders basically have to be in the U.S. They have to be individuals. They can't be corporations kind of things. By and large, not hard to do, because what we're usually talking about, 2 or 3 people, or maybe even just one person starting a corporation. So it's real easy to be careful with those rules, you know. GM can't do that because all that stock's being sold over on the stock exchange. They have no idea who's buying it. Non-resident aliens, all sorts of crazy things, okay? Only one class of stock, so you can have preferred stock and common stock. But then again, I mean, we're getting such a good deal out of this on just the salary coming into us. That's probably not a bad deal. All income tax is always distributed. But again, you're going to be controlling this entity, so you can live with that. If you make $100,000 in profit, you're going to pay tax on $100,000. So you want to make sure that no matter what happens, distribute yourself enough money to pay the taxes, for sure. Greater than a 2% shareholder may be taxed on fringe benefits. Remember, I said fringe benefits were tax deductible in the C Corp, so that's a big difference there. And the tax rates may be higher. Well, the old C Corp was 35, this could be 39. But it's really, you know, when you do this, you got to talk to the CPA, because there's 10,000 moving parts in figuring out what entity you really want to be. Yeah.
Let's say you had a patent and you sold it. The income from that going into an S corporation, what rate would it be charged?
I think it's 21%.
I think it'll still come out as a capital gain, because it was an asset that was held by the corporation that was sold. So I think it's still going to be the same thing. I don't think it's going to matter.
It's a piece of property, right?
Yeah, it's a piece of property.
How about royalties? Would they come in at?
I think they'll flow straight through. But it kind of depends on your royalties. You may just want to hold the royalties in your own name and put them on the tax return. You know, I mean, if you got a working interest in an oil well, that's one thing. That's another whole different kind. But for most royalties, if it's on an agreement coming to you, royalties aren't subject to self-employment tax, right? They go on Schedule E, at least as far as I remember. It's been a long time since I did a tax return. But the bottom line is, Each situation is different, and that's why you gotta go plug it. And you gotta plug it with a CPA who knows your kind of business, okay? Got that one. So limited liability company is the last one. Everybody goes out and creates a limited liability company these days. There are bazillions of them. They're super easy to create. You do it at the Secretary of State. They don't have requirements for officers. They don't have requirements for annual meetings. So they're a lot easier to do. If it's a single member, you're the only person in this, the only owner, it's disregarded by the IRS for taxes, so you just continue doing your Schedule C just like you always did. But you can elect to be taxed as an S corporation. And if you make that election, you're subject to the LLC rules for everything except your tax return, and there you're subject to the S corporation rules. So it can work to your advantage with an LLC to be taxed as an S, okay? Because now I think you've created a pass-through entity, you get to add to that 20% tax rate. The bottom line in all of these is it really depends how much money is coming in, whether it's going to be advantageous to shift or not shift. But as I went through all of these, we threw out sole proprietor because of your unlimited liability. We threw out general partner because it was even more unlimited liability for you and everybody in the whole world. And we really come down to C Corp, S Corp, LLC. Okay? And an LLC, you can have two people together and treat it as a partnership, and that's how we do partnerships these days, because it's a protected kind of partnership. You don't have this unlimited liability for everything to the yellow partners, okay? So those are pretty much the three that you tend to see.
So when you say your law firm is organized as a partnership, it's actually an LLC?
You know, lawyers for years have referred to each other as partners, okay? We are, in fact, an S corporation.
An S corp.
We are an S. Although if you look at our stuff, it says we're an LLC, and that's a long story. But we are an S corporation. Yes?
I guess I don't understand it, because I had a couple S corporations, but I've seen accounting firms, law firms, they're all LLCs. I mean, what is the advantage? I mean, why would they do that instead of just?
Okay, the one big advantage is that in an S corporation, you have to pay out the profits and losses in percentage, in proportion to the ownership interest. So
Take one.
yeah, well, but it all drives off stock. So you own 50%, Dad owns 50%. I have to give you 50% of the profit, 50% of the loss. In an LLC, we can agree that you get 80% of the profit, and Dad gets 80% of the loss.
So that's why law firms do it, because there's partners and then there's peons.
There's partners, there's peons, there's equity partners, non-equity partners, senior partners, junior partners. You can keep screwing with the whole system,
Oh, okay.
okay?
I always wondered I've read stuff, I can never figure out why.
And you're never quite sure. So our thing shows as an LLC, okay? We are a single-member LLC, which is a disregarded entity, owned by the corporation.
And then you file.
See the problem? Well, it's lawyers, you know, it's free. My God, you just start creating stuff. And what it gives us is down below inside the law firm, we can split profits however we want to. They pay up to the corporation above it, where we get out half the self-employment tax, and we distribute the money to the partners.
Oh, okay.
So what you look at isn't what you see, which is so true in
Smoke
life.
and mirrors.
Absolutely, okay? So,
Quick question.
Yeah.
What are some advantages for a Delaware S corp?
you know, for most of what the question is, what about a Delaware court? Delaware did a great job. They carved themselves out as the place to create a corporation. They built a massive body of corporate law. So you see all these big corporations go in there because what you want in the law as a businessman is you want things predictable. You want to know if this happens, this is going to be the result. And that's why Delaware is so good. But little guy like you and me, I don't think it's worth doing the Delaware thing. I'm just fine with Colorado. And I've got clients with Colorado corporations doing business nationwide. So, if they're gonna go public, absolutely, you know, I mean, it's a
I just know
whole
like
different.
startup accelerators, try to push,
Yep.
start in the Delaware
It's
S-corp.
the investors sometimes can push that, because they want the known law, but
Mhm.
the catch is Delaware's filing fees are like, what, 10 times?
10 times at
State,
least.
So it's a lot
And you-
more expensive.
And you have to pay a registered agent who
Yeah, that's
lives in the state where you are, so now you're paying for that registered agent over there. And all of a sudden, it's just like ka-ching. I had a guy that had a Delaware, I think it was an S-corp, and I think it was costing him $3,000 a year to keep it alive. And I just never understood why he needed it, but somebody convinced him to do it years ago.
Does Colorado have a corporate state tax?
We do have a corporate tax, but if you're an S corporation, you don't pay at the corporate level, okay? So, and I mean, I've got very few corporations. Normally when people are running as corporations, they tend not to make a profit because they're taking everything out of it as salary. Because they're trying to get away from the corporate tax. So Roger said, way back when does it make sense to be one thing or another thing? Okay? So let's just think about this for a minute. Let's take somebody who makes $20,000 a year. He's gonna pay 15% in self-employment tax, so that would be $3,000. And let's say he pays 10% in income tax, that's $2,000. So he's gonna pay $5,000 total. So let's put him into an S corporation. He's gonna pay 15% on his income tax, or socials. He's gonna have 15%, sorry, let me think about this. He's got 10,000 as salary, 10,000 as distribution. So on his 10,000 in salary, he's gonna pay 15% self-employment tax, $1,500. And then on the whole 20,000 in profit, he's gonna pay 10% or $2,000. So at first glance, it's $1,500 cheaper for him if he's an S-corp. But if he pays a lawyer to create that S-corp, that first year, I'm gonna tell you, it's probably gonna cost him $1,000. If he pays a CPA to do that tax return, it's probably gonna cost him $500. Savings? Nothing. So that's why you have to look at all of these things and figure out if it's worth it. First, what kind of business am I in? One thing that we see a lot of is years ago, farmers all created corporations. And they had these family farm corporations. And they put all their land in the corporation. So if I have land and I want to go into a business, if I put it into an LLC or a partnership, and I want to take my land back out, I can take it out and there's no tax on me for doing that because that was my contribution in, it's my contribution back out. If I put land or a building into a corporation, I'm allowed to put it in there without any payment of tax. It's called a tax-free incorporation. But when I go to take it back out, the government wants to call it a distribution of corporate assets to me. And I'm gonna wind up paying tax on it. And we've got, what they're gonna make me pay tax on is the gain between when I put it in and the gain when I take it out. So in many cases, put it in today, take it out tomorrow, okay? Put in the farm in 1950 at $50 an acre, and go to take it out today at $3,000 an acre, and Dad's got a quarter down, up at Sterling somewhere. All of a sudden, holy crap, what a tax bill. So it's important to recognize what's happening with the assets. It's important to recognize what's happening with the business operation. So a lot of times we'll see people, so I decide I'm gonna go open Ace Hardware, pick one. So first thing I'm gonna go do is, I've actually got a lot of money, so I'm gonna go buy a building. I'm gonna put that building in a limited liability company, okay? Because if I put it in the corporation, it appreciates in value, I take it out later, I'm totally screwed on that one. If I put it in an LLC, I can take it out later, but I can also create the S corporation that's gonna be my Ace Hardware, and I can rent it to the S corporation, get a lot of cash coming back, and remember, rents are not subject to self-employment tax. So if I set myself a little bit of high rent, I can get a few more dollars around self-employment tax. Now I got this hardware store operating as an S corporation, or maybe I've got 3 partners in it, so the 3 of us create this thing. We each become an S corporation, okay, so that we can play the game with our Social Security taxes. And the 3 of us create the Ace Hardware LLC store. So now I could get half the profit. You can get a third. Dad, you're getting a little bit, not much out of this because we're going to take advantage of you here. But the bottom line is, I can parse things 15 different ways to make it all work. So that's why when you go to do this, this isn't a, oh hell, I'm going to be an S corp and let me do this online. Talk to a CPA. Let them know what you're doing. Let them know what the forward vision of it is. Because they're really the people that are best set to tell you what taxable way to go at it. If we're going to have one rental house, it's an LLC. If we're going to be a really small one-man business, I'm probably going to tell you it's an S corp. But beyond that, when we start getting into more and more things and it just starts getting out of control because you're pretty successful, that's when you need professional advice on this stuff. Yes, sir.
Take the same scenario, but use a patent instead. So I have an S corp and I have my patent in LLC, totally separate.
Okay. So your S corp is manufactured based on your patent. I think you could probably pay royalties to the LLC. Yeah, that would make perfect sense to you. And that way, if you guys do something in the S corp and you screw up this thing and it blows up and kills 57 guys, you may have a lot of problems in the S corp, but the patent should still be protected because it's back in the LLC.
That's why I did it.
Yep, and you went the right road. Makes sense to you.
Except
Questions?
to keep that clean, his S corp has to pay a licensing fee to his LLC.
Well, he wants to pay a licensing fee because when the licensing fee comes in, I don't see licensing fees subject to self-employment tax, right? Aren't they formed like a royalty? I'm pretty sure they're not subject to self-employment tax. So he's just going to pay income on that kitty. Yes, sir.
More nuts and bolts, say you have assets in the LLC, patents, whatever it is, and maybe you're getting royalties. That was set up with me as the sole owner. How about then when you're in a marriage, how those assets pass to spouses and things? Do you have to set something up, or?
As in you die, pass it out?
Yeah,
Okay.
yeah, I'm driving home tonight and,
Well, first drive careful.
yes,
Very carefully. That is basically where an estate plan comes in.
right.
And that is what we do all the time. So I would say you should all have, at a minimum, financial power of attorney. If you are incapacitated and unable to act, somebody, spouse, relative, should be able to access your financial accounts to care for you and pay your bills. Medical power of attorney. If you're unable to make your medical decisions, somebody should be able to do it. When we're older, it tends to be spouse and kids. When we're younger, it tends to be spouse, maybe parents, maybe friends, depending on age, family relationship, all those personal dynamic things that go into it, okay? Some form of a will that leaves your assets or a trust, okay? And wills and trusts, so wills go through probate, and probate really gets a bad name, okay? In Colorado, probate is pretty user-friendly. Typical probate fee, probably $5,000 when you use an attorney, okay? I took it in a state this morning, it'll probably be $1.2 million, and I'm gonna guess it'll cost like $5,000, okay? In California, to probate a $1 million estate, by statute, the lawyer's fee is $20,000. So in California, everybody has a trust. A trust is a will substitute, and it's designed to keep you out of probate. So if we were doing a trust, what I might do is you would assign your LLC to your trust. And this trust is a trust that you could change over life, because things are going to happen. You get older, the kids grow up, they get dumber, they get smarter, whatever, and you adjust the whole kind of thing. So, you know, yeah, so this is a revocable trust, not something that's irrevocable. And what it will happen is if you die and things are set up properly in the trust or to the trust, it would simply transfer to your spouse. If you have a lot of money, it might transfer into a trust that would avoid some kind of federal estate taxes, but she'd have control of it. And then ultimately it would go to the kids. You could just have a will that says, when I die, I leave everything to my spouse. If my spouse is dead and the kids are still young, it would say, create a trust for the kids and, you know, pay their bills, and when they turn 21, divide it into shares and give them the money at 25. But basically, I think those three documents are absolutely key. And if I had to pick between them as a young man, I would go first financial power of attorney, second medical power of attorney, and then third the estate plan. The reason I would have that priority is there's a statute that says if you die without a will, you have to go through probate, but basically everything's subject to probate. If your spouse's kids are all your kids, and all your kids are her kids, she gets everything. And if you don't have a spouse, it's going to go to the kids. So I could live with that. For medical, if you don't have a power of attorney, there's a thing called the Colorado Medical Proxy Decision Maker Act. And it says your family, and that's a kind of undefined term, okay, gets together and picks a spokesman, and the spokesman directs your medical care, okay? But with a financial power of attorney, if you're incapacitated and you don't have one, you are flat out screwed. You have to go to court. We have to create a conservatorship, $2,500 to do that. Annual reportings to the court as long as you're alive and this thing is running. It is a pain. And you can beat that with a financial power of attorney. So that to me is the #1 document. Other questions?
I just have a quick question.
Sure.
On wills, can't you avoid probate if the assets are, what is it, defined benefit? Or
So when you die, stuff passes in a hierarchy, okay? So first thing passes by operational law. So that's joint tenancy. Me and my wife own this house. The deed says Phil and Linda in joint tenancy. If I die, it's hers. If she dies, it's mine. Doesn't go through probate.
it's automatic.
Automatic. Got to record the death certificate and it goes. Next thing, stuff that's a contract pays by contract. So annuities and life insurance have beneficiaries, pays to the beneficiary outside of probate. Okay? Next, all the retirement plans have beneficiaries. Okay? So as long as it's got a beneficiary on it, it'll go. If you don't have a beneficiary, it will fall into probate, and you don't want retirement plans going to probate. The next thing that happens is you can put a payable on death on a bank account or a checking account or anything like that. We've got beneficiary deeds. If I own the house, I can say when I die, you get the house, and it doesn't go through probate. We got transfer on death things for cars that you can say if I die, you get my Porsche or whatever, okay? If I had a Porsche, but I'm working on it. And then if stuff is owned in a trust, the trust controls it. And only anything that makes it through all those wickets and comes out the bottom and doesn't have a place to go. So it didn't have a beneficiary, wasn't in joint tenancy, wasn't in the trust, didn't have payable on death. Only that goes to probate.
So it's just any asset that it's generic and it doesn't have a defined beneficiary. So
If it doesn't have a place to go is the way I think about that.
Okay.
So if I put a beneficiary on it or had an annuity contract or something like that, those will say where they're supposed to go. But it's always important to go back and look at your beneficiaries. I had this guy come in to see me one day, and he had this Gerber life insurance contract, honest to God, and had the picture of the little Gerber baby on it. And his mother had bought this thing for him when he was born in the 50s, and she paid, I don't know, $1 a month for 10 years or some stupid thing. And it was worth $1,500. And I said, who's the beneficiary? And he said, my wife. And I said, okay, look it up. Calls the company up, it's his mother. She's been dead since like 1975. And it's like, never changed the beneficiary. So something like that is what would fall to probate. I've seen people divorced, ex-wife on the thing, or ex-husband on the deal.
So if the beneficiary isn't an entity anymore, then it's.
Goes to probate, because it doesn't have anywhere to go, okay? So, really, you know, that's the whole key to the whole thing. And I mean, we'll have people come in, they've got a lot of assets, they've got a bunch of real estate in multiple states, that's clearly a trust. We'll have somebody come in and they've got a 401k and a house, and we'll typically do a simple will, and we'll do a beneficiary deed. And in my mind, everything's gonna transfer without probate, and the will is my backup. If something goes wrong, it'll go the way they want it to in the will.
Why would you choose the will over the trust?
Because they don't have enough assets to justify me charging them for a trust.
So will's cheaper, I think.
A will's cheaper, sure, and it's got a lot less moving parts. But, so there's reasons to do a trust. Real estate. So, probate courts are state district courts, actually. And a state district court judge can only exercise authority over real estate in the state where he sits. So if I die and I've got a house in Cherry Creek and it doesn't have anywhere to go because it's not a joint tenancy deed, it will go into probate, and the Denver probate court, because I live in Denver, will basically approve the transfer of the house. But if I own the house in Denver and Grandpa left me 200 acres in Nebraska, and I have a little condo to go play golf down in Phoenix in the winter, okay? I've got real estate in 3 states. I need 3 probates to transfer that real estate, okay? So the solution to that is to do a trust and transfer each piece of real estate into the trust. Now, when I die, even though at any moment, at any time while I was alive, I could take that stuff back out of the trust and sell it or give it away or do whatever, when I die, I technically don't own the real estate. The trust owns it. And it avoids all those probate costs. So a lot of times we'll see people with not a great deal of assets, but with a lot of real estate or real estate divided between 2 states, and it's just cheaper to do the trust than to get there. Some states have those beneficiary deeds I've talked about, not all states do. So if there's no other way to make that house somewhere transfer without a probate, I'll go ahead and do a trust as opposed to let it do a probate.
So you don't run into a problem with different states having different laws related to the trust. Let's say you have property in all these different states.
It typically, no, it doesn't affect it. If you get it into the trust, it's okay. Where you do see really bizarre things happen is, so we all live in Colorado, and the good news is that they just made the estate tax $22 million. So only a couple of us are probably liable for any estate tax when we die here. But states have a state tax, not all of them. Nothing in Colorado, nothing in Arizona, Texas, California. But across the Rust Belt, up the central United States, and then coming down the East Coast, down to about as far as Maryland, they have a tax when you die on assets. And if you're a resident in New York State, although the feds say you can transfer $22 million tax-free, the New York State says $1 million, okay? So you think, well, I'm a Colorado resident, that doesn't affect me. But if you own a piece of real estate, you can have stocks and bonds with Merrill Lynch in New York City, that doesn't matter. But if you own real estate in New York State, you well stand a chance to get hit with some estate tax. And there's taxes like that, Pennsylvania, Florida, Pennsylvania, Massachusetts, going up, Vermont, New Hampshire, and then across, Chicago. Think about Illinois. They're flat broke. Of course they have a tax. You know, they got to get money from somewhere.
Even with the trust, I'm subject to that tax.
Even with the trust, you're subject to that tax. I had one client, and this was a number of years ago, and he had about $6 million, and he was gonna move to Minnesota, because he had a beautiful summer house up there. And I said, well, if you move to Minnesota, your whole $6 million is subject to estate tax. If you keep that lodge you got up there, you got $1 million subject to estate tax. So what he wound up doing is keeping his house here, and he visited Minnesota a lot. But he wasn't living there. Filing taxes here, driver's license here, homestead exemption here, all the things that show residence was here. Yes, sir?
So Beck, if I understand, so if you have a will is taking your assets and transferring them to someone else if you die.
Yes,
So the will spells out what happens with your assets.
as does a trust.
As does a
But the
trust.
difference is a will has to go through probate, because here's the real key to it. If I create the Phil Keenan Trust and I put my house in it, I don't own the house, the Phil Keenan Trust does. And my trust says, hey, when Phil's dead, this is what I want you to do with the house. If I own the house, Phil Keenan, and I die, nobody can sign the deed for me. I'm dead, my power of attorney dies with me, dead guys can't have agents, okay? So bottom line is, how do you get the house out of my name to my wife, or to my kid, or to charity, whoever I do with it? And the answer to that is probate, okay? So that's what probate's about. Getting stuff out of the dead guy's name and transferring it when there's no automatic operation that makes it happen.
So that would be back to, again, why you would maybe want to set up this trust for an LLC because of the assets in there.
Yep,
That you're avoiding that issue.
absolutely.
And I could exist without a will if I had all defined benefit assets?
You could. But if something gets screwed up, you've got a defined benefit. It's all 401ks. So you got 10 of them.
The benefit died on me.
No beneficiary on one of them.
Okay.
Now it doesn't have somewhere to go, so it's going to try to go through probate. And the other thing that happens, if you have a retirement plan like that with no beneficiary and you die before the required beginning date, remember you got to start taking money at 70 and a half. So if you die at 68 and there's no beneficiary, they're going to make that damn thing pay out over 5 years, no matter how much money's in it. As opposed to when do our 401ks pay out? 40 years or whatever, they go on forever. So making sure the beneficiaries are right is a big time deal. Really, really important. All right. I noticed that there are still brownies in the back. So
I have a question.
sure,
So-
I'm going to stay around for a while anyway.
So
Go ahead.
basically, Trump's new tax plan, there was a House bill or Senate bill, I don't know which one, was gonna switch from patents to capital gains to income. And then at the very 11th hour, went back to capital gains, which is good. But capital gains, you have to hold it for more than 1 year, right? So let's say you have,
Well, the answer is yes, but a capital gain is paid on the sale of a patent.
right, so let's say,
Sorry.
I have a patent portfolio with like 8 or 10 things in it, and so I'm gonna sell it, but everybody's interested in the last patent. But that's just brand new, that's not, I haven't held that for a year. And
So
then
capital gains is defined as 1 year.
1 year. So you would tell the purchaser, you're buying these patents for X amount,
And
and
why
this
don't
new
you
one.
lease this one from me and pay me royalties for a year, and I'll sell it to you next year?
And then the other thing is, I actually filed for these patents in 2002. I had another company, it was doing well, I don't know why I even had this idea, so it was death to me. So anyhow, it took 9 years to get this first patent. And then I filed Palm Pilot, HP, Royal, whatever. I finally get this patent after 9 years. Found continuation, it gets broader, I have another one. I win this contest out in Silicon Valley, I get sued by a publicly traded company. So I took all the patents and I started paying for them personally. So I moved them out of the sub-S corporation, right? So now I've been playing whack-a-mole with these patents. So I own them personally now. And so now I'm, thinking, well, sub-S is 21% now, and I'm reading about Amazon, all these companies at 13.5%, whatever, you know what I mean? So if I transfer the patents that my husband and I know personally, because I hired a patent broker just recently, this is why I'm here. And so, and everybody's excited, I'm getting all these incoming calls, but if I transfer it to sub-S, I can set up a sub-S in 30 minutes, but I mean, is that capital gains or is that a new asset because it hasn't been in the company for a
I
year?
don't do this every day, and that's why I keep saying, talk to a CPA.
Oh, okay.
And if I can give you the name of a good CPA, I'm sure you know some guys that are really good.
But if a sub-S gets patents like, within a couple weeks, is that a capital
But
gains?
I'm more, well, if you transfer them to a sub-S, there's nothing there, and I think the holding period's capped from when you started to when it sells. But I'm not sure the best way is to sell them out of the S. I don't know the answer to that.
Yeah,
And I think you need to talk to somebody who deals with that on a daily basis, and that's back to the tax guy.
oh, okay.
All right? Well, thank you very much.
One thing that comes up, when you start a business, let's say you typically start an LLC, and then you spent the money on your patent over the first year.
Uh-huh.
Is that, the way you're gonna deduct that expense, can that be all at once in section 179, or can I amortize it, or do I have a choice?
What kind of expense is it?
Say about $5,000.
No,
This
not
is-
an amount. What, legal fees or fees to establish the patent, or?
Everything, the file fee, the patent fee.
I think that's amortizable, but I'm not 100% sure, because I don't do these returns every day.
Oh, okay. Because people ask her, and now, how do I deduct the patent costs? Well, it's like, it's a property with a 20-year life, in a sense.
You ought to get a CPA who does that in to talk. I think it'd be fascinating, and I think you'd get great questions, and he'd love to do it because he'd probably get business out of it. There's got to be a victim out there somewhere.
Yeah, I think usually people want to defer the expense when they have the revenue.
Until they have some revenue to go with it, yeah.
There's nothing to gain by deducting it.
But I don't know that you can actually defer it. If you're a cash basis taxpayer, it would seem to me.
I don't think you get, I've never been able to do
I
that.
mean, how have you been doing it all these years?
Yeah, I mean, I just like, write it off, like Kramer. I mean, I don't think you can, it's not really an asset, until somebody writes a check for it, and how do you even determine what it's worth? I mean, it's just,
Yeah, well, that's a whole nother issue, but what you spend on it is a fixed number.
and how do you even defending it?
It's an expense, your legal fees. You write it
But
off.
you had income that year to expense against.
I would certainly think the defense of it is probably an expense in the year it's spent.
Yeah.
I just
The setup fees, I mean, it seems when you set up a corporation, supposedly you're supposed to amortize that over time. I don't see it's any different to set up a patent, but I'm not
Yeah, 'cause
100%
it's like,
sure
what
of
if you
that.
bought a machine or a piece of equipment, and it's gonna last 10 or 20 years? I mean,
you can
you
depreciate
can
that.
expense that or depreciate it, depending on what works best, I guess.
It's pretty warm, that's why it probably wasn't working. Right in front of that little light there.
Oh,
So you're all excited about the new tax stuff?
Well, I'm excited from the estate planning perspective. I mean, holy cow, 22 million bucks that you could transfer estate tax free with the government getting nothing out of it. That
and
is
it
a
was,
great
what,
deal.
$1 million?
Huh?
It was $1 million?
It was it used to be 11 million per couple, and what they did is they basically doubled it. Now, for most of us, the reality of that is,
Doesn't-
1% of the United States, when we were at 5 million bucks a person, 11 million a couple, 1% of the United States filed tax returns on it, and 0.2% paid taxes. God only knows what 22 million has done to it. Maybe 1/3% will file returns, and maybe 0.005 will pay any tax. I mean, it's,
Yes, one in 5,000 people. I mean,
yeah, I mean, that's a 22 million bucks is a lot of money. But for people that have 100 million bucks, there's still a lot of things you can do now to make that stuff transfer tax-free. I mean, obviously, that's why we exist, is to find ways not to pay tax or to leverage. That sounded horrible, didn't it? Yeah.
well, I
that
didn't
on your
realize
business
that
card?
there's such a state tax problem with that, because that could be meaningless if the state has a high inheritance tax.
Yeah.
And they're all different, right? So-
Yeah. And they have all sorts of different kinds of taxes in the states for that inheritance tax stuff. Some of them tax the dead guy on the right to give you money. So if I die and I've got $10 million. I pay tax and then I distribute the money. Some of them have what's called an inheritance tax, and the inheritance tax is based on the relationship you have with the guy you're giving the money to. So if you're giving it to your spouse, there's no tax. If you're giving it to your kid, it's 2%. If you're giving it to your nephew, it's 5%. If you're giving it to a stranger, it's 10%. It's just bizarre. But most of that, again, across the Rust Belt, down the Northeast, because they're all broke.
Did Frozen Dead Guy take care of things correctly?
Yeah, I think Frozen Dead Guy did just great. He's got it all under control up there.
You should say you're his accountant, and people, he'll be like trying to call you.
As long as you can get out alive, you probably are. I guess you can't get out alive, can you? I think we're stuck with it. So, well, hey, thanks very much. If I can help you on estate planning, give me a buzz. I've got cards if anyone would like one, and Roger knows where to find me, which is never good. So, thanks very much for coming.
And I might mention that you run a class monthly, right?
Yeah, but that is really for professionals, and because it's designed as continuing ed for CPAs, attorneys, insurance, CFPs. So it's usually not for the general public because they're usually pretty specific stuff, life insurance trusts and probate, all the crazy stuff that we do over there. So, well, you're back in charge. I'm shutting up.
Well, thanks. You can stay as long as you want. Please enjoy the snacks and everything. Thanks for coming.